They said no. And they took it to court. And at court, they were awarded, they wanted to adopt, so they were awarded permanency or some sort of interim order that would eventually lead to the adoption. And Linda Woods, the mother, she appealed. It went to the Court of Appeal and she won. And the judge there said all sorts of good things and said the child should be with the mother. So then the Racines took it to the Supreme Court. Now, how long does it take to get to the Supreme Court? Long time. 7 years later, 8 years later, now Letitia is 10 years old, and it's being heard at the Supreme Court. And Justice Bertha Wilson basically said two things. So they won. They were awarded, custody, permanency of Letitia. And Bertha Wilson said two things. She said, one, over time, the significance of culture abates. And the second is that when children are in care for any period of time, precedence has to be given to the adoption or the bonding that they have now developed with the foster or temporary caregivers. She said this child should not be allowed to become a battleground in the courts or in the media when the test to be met is the best interest of the child. The significance of cultural background and heritage as opposed to bonding abates over time. And one of the expert witnesses in that particular case said, yeah, this culture, this Indian or culture thing or whatever isn't as significant as bonding with the foster family. Well, let's be realistic, right? She's been there for 7 years. But children are also very astute. She was very aware of what was going on. But there's so many things about this case that are problematic, and mostly it's that neither of those statements are true. They're both fundamentally flawed. The reality is that bonding and attachment are ideas, and they're not quantifiable. You can't say, you're more attached to your mom than you are to your mom. Like, how are you ever going to figure that out? Assessments of bonding and attachment are always subjective assessments on the part usually of foster parents or prospective adoptive parents, and social workers, and the expert witnesses. And they all rely on John Bowlby. So I tried to create sort of a quantitative framework for a non-quantifiable topic. What did that say? 20 minutes? Oh, good. Okay. And having interviewed and read narratives of hundreds of survivors, what I know is that in terms of indigeneity, 99.8% of Indigenous children in foster and adoptive homes repatriate to their Indigenous family, community, culture. It's a fundamental human instinct to want to know who you belong to. And if that's never been disrupted, it might take a little bit of sort of, reflection to understand what that means. So those of you who have children, or many of you are young students, you're going to get married, maybe not married, you're going to have children. When your child's about 3 years old, this is in the future, I want you to look at them and imagine what you would do if they suddenly disappeared and you had no recourse. And as trained lawyers, you're going to go, I'm going to do something about this. I'm a lawyer. No recourse. Imagine. Feel free to email me when that happens. I will help you through the trauma of that thought. So the other problem is that Supreme Court cases are binding on lower courts, right? Even if they're nonsense. So pretty much every single child welfare case since Racine and Woods has used this case to justify the removal of our children and the issuing of permanency and adoption orders. And it doesn't matter how long the children have been in care. And what I find extremely problematic and egregious is that in some instances, it seems, when I read, because I do a lot of expert submissions, so I get to read the cases, it seems that when it's in the interest of augmenting this particular decision, there will be court delays, time delays, so that when it does get to the court date, there's legitimacy and veracity to the argument of the child's been in care now for 2.5, 3 years. We can't disrupt that bonding. But even with children who are a little bit older, who may have had a primary bond with their birth family, that bonding, that original disruption is never given any consideration or weight in law. So I was firmly attached to my family at the age of 3.5. And I had never attached to my adoptive family. And I have talked to many, many survivors who were adopted at birth and never attached to their adoptive family. For a number of factors, right? There's the difference factor, and it's a big one. It's, that you know that you are not biologically part of this family. But then there's also some of those more sort of heinous aspects of intrafamilial racism, so within family racism. So it's very common that adoptees would hear things like, if you don't behave, you're going to end up like all those other Indians. What a thing to tell children. Okay? Unpack that one for a bit. So legal and policy systems create delays that augment the longevity in care. And so if a child has been and all agencies have done it, if a child's been in a foster home for a while and they're working towards the transition back to birth family, if the foster family says no, we want to apply for permanency. Agency policies have developed to give them their day in court. And once it gets to court, then Racine Woods is used and we're sunk. Now, we're having an impact. And the impact is that, and I like to think it's all because of me, but I know it's not. I do my little small part, right? People are working on this all over the place. But there's one woman, I got asked to do an assessment of a need for a parental capacity assessment. For this woman whose kids who had been in care for 10 years. And she had been fighting for 9 friggin' years to get her children back. And this was just the last in endless obstacles faced by social workers and experts who had never even met with the children. They'd write these reports about how the children were unattached and this and that. Never met the children. So be very discerning about the things that you read. And I read this. This mother was very smart. In the first year after her children were removed, the father had been beating the boys. And she broke up with him. He was charged. He spent time in prison. And in that first year, she missed 1 court date because she was despondent. She had an existential enemy. And then something happened, and she kind of got smart, and she kept every single note, every email. She recorded every phone call. She kept detailed notes of every time she went to visit her boys, and the social workers would say, "Oh, your worker's not here today," or "Oh, you have a new social worker," or "Oh, your file has been transferred to a new supervisor. You're going to have to come back." Her affidavit was 76 pages long. And when I read through all the material, I said, this is basically a conspiracy among the social workers that she's encountered. And I had to reflect on a long time, why would they do this? And as a social work educator, I understand that many people are disempowered. And when you give a disempowered person power, chances are they will abuse it. And so these social workers did not like that she advocated for herself. They didn't like that she recorded their phone calls. So they retaliated by putting up obstacles